My name is Roland Mumford with Mumford.Law, and I litigate Section 1983 police misconduct law, employment discrimination law, and misdemeanor criminal law cases. In this video, I want to answer the question, do lawyers lie, or is there often an odor of mendacity, which is a phrase I love that a judge used in a case against the Atlanta District Attorney and President Trump? The answer is yes. Here are 10 hypothetical examples of attorneys lying or there being that odor of mendacity. Number 1. In a divorce case, a lawyer may lie about needing to conduct discovery or such other excuse to drag the case out. Why? To allow additional time for an asset to vest and become marital property. This could be a husband's stock option or his annual bonus, and that can be more money that the wife would seek. Upon the asset vesting, all of a sudden, opposing counsel calls and wants to schedule mediation. Number 2, attorneys lie about scheduling all the time. How do you know? When opposing counsel needs to schedule a motion on the next immediate docket, they are available. But when it's your attorney's motion, opposing counsel is conveniently not available. Now, of course, often attorneys do tell the truth about not being available, but there are attorneys that do lie. I remember when I first started practicing law, and one attorney would tell me he could not be available for the next 2 months and always had to be in criminal court on that particular Wednesday. However, he filed the petition in this court being a civil court. Number 3, attorneys sometimes malign another attorney in court. For example, an attorney may tell a judge that opposing counsel was delaying taking depositions for a number of months, when in fact, it was that very attorney that was not available, and there were emails to demonstrate that. Number 4, attorneys sometimes may tell a court that it took a long time for a party to complete discovery, and that was the reason 4 months had gone by, and yet discovery had still not been produced. Written discovery is answering questions such as interrogatories and producing documents that are requested by the other side. But the complaining attorney sending the discovery could download their client's bank statements for 3 years in 10 minutes from the bank website and could download 2 years of payroll stubs from the client's employer payroll administrator in a matter of minutes. Number 5, an attorney may not tell the truth about classifying an asset or a liability as marital or separate property, meaning whether it was acquired before or after the date of marriage. Number 6, an attorney may say that they have no other documents to produce, such as bank statements. This is because they want to avoid proof that a party was earning additional income and the deposits in the bank account may show it. Number 7, an attorney may lie about certain communications between counsel never having occurred, but counsel was looking down at his phone and has a call log. Number 8, an attorney may lie about not having any more authority to settle a case when in fact they could have increased the offer to settle. That often happens in personal injury matters or employment discrimination cases that I litigate. Number 9, an attorney may represent to counsel that all documents have been produced and then show up at the person's deposition and hand them 75 pages of an employment file. How is that attorney supposed to review that many pages in a matter of moments to properly depose the person who is the subject of those documents? I actually had that happen to me in an employment discrimination case in federal court. Number 10, finally, one big one to catch is a lawyer miscounting the number of days in a child support calculation or counting parenting time at mediation and then provides you and your attorney the parenting plan and child support calculation. Or they will provide you a child support calculation template that is several years old and not the current spreadsheet the state uses. Many states have updated versions of their child support calculation, and if you receive a much older one, then the child support is very likely to be higher for that parent to pay. Thank you for watching, and please click like and subscribe, and visit us at Mumford.Law.